continued to April 8th, 2024. FSC 327, 2024. No extension on dates relative to the trial date, except expert witnesses. That would run concurrent with the new trial date. If anybody disagrees, speak up.
Great. Thank you.
And I don't think that you can hear, the court will let you argue anything. The clerk announced it, said it's going to be available at 1:30 in the court's queue. And that's been my experience. They just come on, they rule, and it's done.
Wow. Yeah, I wasn't expecting April, but okay.
That's what we got.
Yeah.
All right, so I'm going to hang up now unless anybody thinks we need to stay on.
Kyle? Kyle, are you staying on or going to try to do anything, or can I get off?
Good morning. Before we begin, we're having a technical problem here, and I can't see any of you. The Court Connect screen that would let me do that, and I'm assuming let you see me, although I don't know. Or maybe the camera.
We can see the gallery.
You can see the gallery, but you can't see the courtroom. Is that right?
Correct.
Okay. Well, we'll just forge ahead anyway with audio, and I guess you'll all be able to see each other, but I won't be able to see you, and it sounds like you won't be able to see me either. But here we go. So we'll begin with Luis R. de la Cuesta Monroy versus General Motors LLC. Appearances, please.
Good morning, Your Honor. Vivian Lorchie, specially appearing for plaintiff's counsel.
Good morning, Your Honor. Nora Grieving for defendant GM.
Good morning. Okay, so we're here for a case management conference today. Thank you for submitting your case management statements. We'll go ahead and set a trial date, the earliest available date for new cases. Mr. Flettis? Okay, does June 10th, 2024 work for you? 9 a.m.
That will work for plaintiff, Your Honor.
And likewise for defendant.
Okay, so that is the trial date. And what's the final status conference date, Mr. Flatus? May 31st. Final status conference, May 31st, 2024, also at 9 a.m. I'm going to order a status conference in about 120 days. Do you have a date for that, Mr. Flatus? October 12th. Any objections to October 12th, 2023 for that status conference?
That's fine with plaintiff, Your Honor.
Works for defendant.
Okay, that'll be the status conference date at 9 a.m. I'm going to order the parties to submit a joint status report. The plaintiff is ordered to actually file the report. The defense is ordered to cooperate in its preparation. The report should include, among other things, the following: a report on what discovery has been completed and what discovery remains and when you anticipate it occurring, any motions that are planned, also what plan there is for resolution of the case, specifically whether you're planning to do private mediation or mediation through Resolve Law LA, that mediation service, which is free. Is there anything else today?
No, Your Honor, that's fine. If I could just go ahead and confirm the date. So,
okay.
Trial June 10th, 2024, final status conference May 31st, 2024, and status conference October 12th, 2023. Is that correct?
Yes, all at 9 a.m.
Thank you, Your Honor.
Okay, thank you. Is notice waived?
Yes, notice waived.
Notice waived for defendant. And, Your Honor, I'm also on a case called Barron versus Entertainment LLC. Wondering if the court can call that. I'm okay waiting too.
I'll call that. I have just one case that I actually meant to call first, and with our technical problems, I forgot where there's a request for priority. I'll call that priority case, then I'll call the Barron case. Okay, calling Raymond Saroff versus the Standard Fire Insurance Company. Appearances, please.
morning, Your Honor. This is Tanner Havens on behalf of the plaintiff.
Good morning, Your Honor. Kristen Ingelsrud on behalf of defendant.
Okay, good morning. Well, we're here for a case management conference today. The court has, you've probably already been told, granted the ex parte application to dismiss defendant Kennedy. Thank you for the case management statements. I'm going to go ahead and set a trial date. What's the earliest available date for new case, Mr. Flatus? September 30th. Okay, the September 30th, 2024 work for both of you.
Yes, for the plaintiff, Your Honor.
Yes, for defendant.
Okay, and that's at 9 a.m. We'll have the final status conference on, will that be September 20th? September 20th, 2024, also at 9 a.m. I'll set an intermediate status conference in about 120 days. On what date, Mr. Flatus? October 13th, 2024 at 9 a.m. I'm going to order the parties to submit a joint status conference report to be filed by the plaintiff with the cooperation and participation of the defense. It needs to address the status of discovery, in other words, what discovery has been completed and what remains to be done and when, any anticipated motions, and you both indicated that that you intend to mediate, so I want you to tell me what mediation is planned and when. Is there anything else today?
Nothing from the plaintiff, Your Honor. Thank you.
Nothing from defendant, Your Honor. Thanks.
Is notice waived?
Notice waived.
Notice is waived.
All right, thank you. Calling Yasmin Barron versus Entertainment Center, LLC.
Good morning, Your Honor. Nara Gribbin for plaintiff.
Good morning.
Good morning, Your Honor. Bert Strzok on behalf of the three defendants.
Okay, good morning. We're here for a case management conference. Thanks for the case management statements. Actually, do I have an appearance on behalf of Cypress Insurance Company?
Your Honor, I believe Cypress just intervened on the case, and the defendants just answered. We still need to conduct discovery. Plaintiff's request would be a 90-day continuance of the CMC to allow the parties to meet and confer in the case evolve.
Well, I'm going to go ahead and set a trial date anyway to get you on the calendar, but I'm going to set a status conference as well. I'll put that out a little longer to give you all a chance to work that out, to figure that out. So let's go ahead and set a trial date. What date do you have, Mr. Flatus? October 7th. Okay, does October 7th, 2024 work for you?
Works for plaintiff.
Yes, Your Honor.
Okay, and that'll be at 9 a.m. The final status conference will be on what date? September 26th. September 26th, 2024, also at 9 a.m. We'll set an intermediate status conference in about 150 days. Do you have a date for that, Mr. Flatus? November 16th, 2023 at 9 a.m. I'm going to order a joint status conference report to be filed by the plaintiff with the participation of the other parties. Please include a discussion of the status of discovery, what mediation or other alternative dispute resolution the parties are planning, and what motions are anticipated. Is there anything else today?
Not from plaintiff's perspective. Thank you, Your Honor.
No, Your Honor. Thank you.
Thank you. And I'll ask plaintiff to please give notice.
Will do. Thank you, Your Honor.
Thank you. Calling Ray T. Brown versus ammigee et al. Appearance, please.
Good morning. Ray T. Brown here.
Good morning, Jody Rosner.
Good morning. Okay, so we're here today on a motion or on a demur and a motion to compel further discovery. The court posted a tentative ruling. Do you wish to be heard, Mr. Brown?
Yes. I didn't see the ruling. but would you mind telling me?
Well, the ruling is that the court would sustain the second demur, really for the same grounds that the first demur was sustained for, but this time without leave to amend, because you were already given that chance. And then it would furthermore deny the motion to compel further discovery on the grounds that it's moot, given the sustaining of the demur.
I see. Okay. Did you consider my argument against demur?
Yes, I did.
Okay. So, what was your? I mean, I'm not.
This is the thing. This is Mr. Brown. And I have this discussion with you before. You're at a disadvantage because you're not a lawyer. But what you've done, it looks to me, is you've pulled together a bunch of legal phrases and concepts and so forth, but that, to be perfectly honest, don't make sense.
Well, yeah,
You just asked me to explain myself, and so I'm doing that.
Okay.
And don't address the issues that are being raised. And if I recall correctly, I even suggested to you, if you can't get a lawyer, you might seek out help from the county law library, where they have resources for pro per litigants. Because the fact is, you simply didn't. What you put together, just to be really clear, didn't make any sense.
Okay.
And it didn't address what was in the court.
Okay.
I'm sorry but I am going to end the ruling as the order of the court.
Can I make? You asked me if I had a statement to make.
Go ahead. If you want to argue, go ahead.
Yes. I did, in fact, specify in the objection to demur that I cited negligence against the defendants. They're in illegal possession of my security deposit. That was the premise of my complaint from the outset. Nothing has changed. Only thing that has occurred is that the court has made me explain this in perhaps a dozen different ways, trying to get the court to accept the fact that I've been violated. And as far as demur goes, the tried and true fact of my claim has been stipulated by the demur evidence. They attached their breach of contract lawsuit against me in their defense of the demand for my security deposit. So I don't see how that is pretty clear. They have the security deposit. They've had it for 3 years. I've been at a disadvantage. I mean, that's my property. I've been deprived of my property. And the law that I've stated and conveyed and structured around my claim as to the negligence for them to, at this point, continue to act in this violative manner is all I've said, and that's pretty clear. I mean, if there's a place that you need me to point this out in the pleadings, I'd be happy to do so, but it appears that you're not aware of this.
All right, thank you. You know, you have probably tried this you said a dozen different ways, and the court has given you a lot of chances. And look, I'm not happy to have to give you this ruling, because you strike me as a sincere litigant. But the mere fact is that legally, what you're submitting to the court isn't sufficient to do what needs to be done. And frankly, it's not. It doesn't make sense, and so I can't make heads or tails of it.
Well, I don't understand, Your Honor, because
I'm not going to argue with you.
I'm not arguing. I'm just saying that if the demur states that
Document ruling is the order of the court.
the demur states that it fails to state a claim, which is my security deposit, and it fails to state a method of relief, which is returning the security deposit. Are you saying that that's unintelligible? Is anyone there? So this is the game we're playing. I just didn't want to hear the truth. They let someone walk in off the street and file a demurrer. In my case, they understand that. And I know he hates to do this, but he's compelled by higher forces to do so. So I'm just going to sue him again. I've already got my writ of execution. So, and now they just hung up on me, it appears. It's pretty professional and very American. You're not going to get another fucking prisoner out of me, no matter how hard you try. And I'll beat you. Shit before I even argued. Bullshit on me.